primary point taken is that no draft memorandum of appeal has been annexed. My Lord, in both the notice of motion itself, as well as in the affidavit of the Cabinet Secretary, the proposed grounds of appeal have been set out extensively. I need not repeat them here because they are on the court record. And so therefore, the submission that no arguable appeal has been demonstrated is one that we need not confront. Let me deal with the more consequential limb, my lords, your ladyship. That is whether or not the appeal will be rendered nugatory. Well, the principle that emerges from the authorities that we rely on is that the question of nugatory is a practical one, is assessed from case to case, and it is not confined to physical or legal impossibility as suggested by the respondents. It covers cases where success on appeal would be hollow, and in this case, because the opportunity, the value, the timing, or the window for this transaction has been lost. And so we want to make 4 quick points in relation to the circumstances of this matter. First and foremost, this is a time-sensitive transaction. It is market-facing, it is cross-border, and it involves considerable sums of money, 204 billion shillings as consideration for the shares, and 40.2 billion shillings to be paid upfront in relation to the advance dividend that the purchaser proposes to pay to the government in consideration of the sale of its shares. An indefinite freeze, my lord, risks the buyer, in this case, either repricing, deferring, or walking away, and that entire opportunity would be lost. Secondly, it is a hard currency inflow. This country is in dire need of hard currency. This is a foreign strategic investor. The liquidity that would be pumped into the coffers of this country, the relief on our forex reserves are a matter of public economic significance. This introduces a public interest dimension to the application. My lords, the Cabinet Secretary has deponed to the use to which these funds would be put, the National Infrastructure Fund, budget support, fiscal stability, long-term savings. All these appear in the resolution by Parliament when approving the transaction. So this is not merely a matter of commercial delay, my lords. It is a delay which would significantly, irreparably prejudice public finance objectives, which go beyond the narrow interests of the respondents. My lord, that delay is neither compensable nor is it reversible. The lost timing, the lost inflows, and the lost market window cannot be restored by a later order or by a successful appeal. In essence, therefore, that lost opportunity is the very item that would declare the appeal or would render the appeal nugatory. The primary authority that we rely on, my lords, your ladyship, is the decision of the Supreme Court in Munya versus Dixon Mwenda Kithinji, which relates to the safeguarding of public funds and the proper husbandry of public resources. It's our respectful submission, my lord, that we have made out a proper case for the grant of the conservatory order. We rely fully on the submissions that we filed. Thank you very much.
Thank you, Counsel. I have a question for you. Just wondering, the stay a conservatory order, is it a strictly usual 5(2)B application? I mean, you are asking for a stay
Yes.
of a stay, basically a stay of almost a stay. Does the jurisprudence you are citing fall on four, squarely with what you are asking?
Yes, my lord. I mean, the court has jurisdiction to grant a stay of execution, a stay of proceedings, a stay of an order. So therefore, it falls within the jurisdiction of this court, and it is not novel. It is not new. This court has engaged with applications of this nature in the past, and has had the opportunity to render itself. So it is not.
Have we given authorities where we have done that, where we have actually given stay of orders given by the High Court?
My lord, I can point to the Supreme Court, again, Munya, and you yourself say that this court was hierarchical, and so therefore, in our respectful view, you should take your lead from the Supreme Court. In any event, my lord, whether we are talking about a commercial matter or we're talking about a constitutional matter, the jurisdiction of the court is set out in statute and in the rules. And it is for this court to engage with the application and to determine whether it meets the parameters set out, the jurisprudence that this court has previously espoused.
Okay. My Lord Mchelule, any question for counsel?
Presiding Judge, Senior Counsel, there must have been an exercise of discretion on the part of the court that determined that there were sufficient grounds for them to grant a conservatory order. And we know the jurisprudence around discretion. I haven't seen that you have addressed us on whether there was proper or improper exercise of discretion on the part of the court.
My lords, we have set that out as one of the potential grounds of appeal. That is premised on the contradictory nature, my lord, of the discretion as exercised by the High Court. My lord, on the one hand, the court recognized that this was a transaction that required multiple regulatory authorities to determine. It was a transaction that was incomplete. The court clearly recognized that. It was a transaction that would require competition authority approval, communications approval. Parliamentary approval had already been granted, and that is a ground of appeal that we have advanced and will be advancing. My lord, you will see, in fact, at paragraph 2 of our written submissions, we have addressed that. The High Court held at paragraph 221 that parliamentary approval had not completed the transaction, that no contract had been executed, and that the substratum remained intact because the process still required further statutory and regulatory approvals. Yet at paragraphs 225 to 227, the court nevertheless concluded that unless the process was stopped, the petition might be rendered nugatory and proceeded to grant a blanket conservatory order. The intentional tension alone is a serious appellate point. This is the stuff of which discretion is made. My lord, discretion is not an open-ended book. It has to be, discretion is judicial. It depends on the parameters upon which it is exercised. I hope I have answered your question to your satisfaction.
Thank you. Thank you, Presiding Judge. Thank you.
Thank you, my lord. Milady, any question for counsel?
Just an observation, Senior Counsel. So if these impugned transactions are allowed to go on and be concluded, and these constitutional questions are not answered as the respondents would like, so at what point would they then be ripe for consideration? Would it not be too late?
No, my lord, it will not be too late. My lord, it was open to the bench, the High Court, to grant a structured conservatory order such that all the regulatory processes would, A, be dealt with and ticked off, and then the transaction could be halted before consummation. But now what we have is a situation where the transaction is time-bound, the regulatory bodies required to engage with it have been stopped from engaging with it. The cabinet has approved the transaction. The Parliament has approved the transaction. So in fact, we have a situation where it has moved from a transaction that is under Section 87A of the Public Finance Management Act, which sets out the considerations, to one that must now await every possible regulatory body must await the decision of the court. We don't know when that decision will be rendered. And by then...
I think that's all right, Senior Counsel. Thank you, my lord.
Very much.
Thank you very much. So we heard you, Mr. Muganda, say you would, do you say you would say a thing or two? Or you're saying nothing? You ceded all your time?
My lord, I have nothing useful to add to what Senior Counsel has said.
Oh, great.
Thank you.
So, Mr. Muganda, you just concur?
Fully, my lord, and I seek the clearance be granted. Thank you.
Okay. Mr. Musangi.
Yes. My lady, my lords, just 2 points, and this perhaps will pick up from the questions their lordships asked my learned senior, Mr. Ohaga. My lords, there were 2 points that in the exercise of discretion, in our view, the learned bench erred on. And number 1 is when your lordship asks about the stay of a stay. Ordinarily, a conservatory order is intended to conserve a position in a neutral manner.